Good morning. It's a reminder, the cases are live streamed or the oral arguments are live streamed and then will be placed on the AOC website. So if that impacts anybody, you know it's there forever. Call the first case, please.
Cheri, Howe versus Donovan, Todd, Howe.
We'll hear from the appellant when you're ready.
And I'd like to reserve 5 minutes for rebuttal.
That'll be fine.
So with respect to this particular case, it deals primarily, my portion deals with Rule 60.01, which deals with clerical errors, which I am certain the court is aware of. And what we have is a final decree that was entered in connection with a divorce proceeding that references a marital dissolution agreement, but a marital dissolution agreement was not attached to that final decree. With respect to the terms of that final decree, I'm not going to belabor those. I will just say that at some point in time in February of 2023, there was a petition for contempt filed in connection with the Part 1 of Chancery Court. For the purposes of the record, the original judge that signed the final decree was Frank Brown. At the time of the petition hearing, the judge is Pamela Fleener. It makes a difference in some part with regard to not only a nunc pro cope issue, but also with respect to a clerical error issue. Specifically, with regard to the failure to, quote, attach, if it is a failure, I might suggest to you it may not be a failure if you don't really know, other than what Ms. Raymer said at the hearing when I moved to dismiss the case because the final decree did not have the MDA and she did not comply with Rule 10 of the Rules of Civil Procedure, which required her to attach the document to the petition for contempt, or at least say that I had the document in my possession in connection with that. And so with respect to the grant of that dismissal, the court considered both the Rule 10 issue and also the lack of, as far as she was concerned, of clarity in the sense, not that the decree was invalid, but clarity of the decree, because it did not contain the terms of the MDA in the payment of certain items that were to be paid that they were seeking contempt for. The interesting thing about that, you could say that an error occurred or a failure occurred when the decree was entered in 2014. Just for the purpose of the record, the MDA, as I'll call it, was signed in December of 13. So in February, it's not attached to the petition. The decree does not have it. In June, I file an answer to that petition. And in filing that answer to the petition, I point out that the MDA is not attached to the decree. So we have a 200-day or more period of time from my answer that was filed that notifies the court that there is no MDA attached to the decree, and there is no MDA referenced in the no MDA attached to the petition for contempt. I did on the first day, as a preliminary matter in connection with the proceeding for the petition for contempt, I moved to dismiss for the failure to have both clarity as to the order with respect to its terms, not that it was facially invalid, because facially on its face it made sense, And secondly, I did it because the Rule 10 was not followed by, with respect to the rules of civil procedure.
Mr. Konvalinka, if the petitioner had attached a copy of the MDA to the petition when it was initially filed, would that have taken care of the problem?
The answer to that question is likely. I mean, I can't, I try to think of more things as I can, but likely it probably would have, quote, taken care of that issue. But the interesting thing what I was going to comment on is when we arrived and we discussed it as part of the argument on the motion to dismiss, Ms. Raymer, who was counsel of record at that time in connection with this proceeding, stated to the court that she believed, there's some discrepancy between what counsel for the appellee says, but I think it's fairly clear that the judge said believed. They say might. I say she believed that the MDA was under seal. The judge then had the judicial clerk for her court search for it. She actually put her on the witness stand when she came back and examined her with regard to the issue to see if she had found anything or any notations with respect to it. And she did not. And so, again, I think, in fairness, Ms. Raymer, I think the parties may, again, we're looking at 2013 and 2014, may have not wanted the MDA attached. I mean, there are some people who don't. This is a fairly significant amount of money that's involved in connection with this MDA. But the point is, it was not there. The judge made a decision at that time, since there wasn't clarity of the order and there wasn't compliance with Rule 10, she was going to dismiss it without prejudice with respect to refiling if they wanted to file a contractual action instead of a contempt action. Subsequently, obviously—
Let me clarify this. The problem with the MDA not being in the record wasn't just, oh, there has to be an MDA in the record. Like, there's no requirement that it had to have been filed when the final decree was filed. It only became a problem because they were seeking contempt, they were seeking to enforce terms of the MDA, and so it needed to be somehow in the record. And so it wasn't, and I think the trial court's issue was primarily one of notice to your client. Like, how is this person supposed to know exactly the terms that they're alleged to violate if it's not attached to the petition, if it's not in the record?
That's exactly correct. The only thing that I would tell you, there is this divorce was granted under 36-4129, which was the stipulated grounds for the divorce. I think there may be some law out there that says, with regard to one that's a statutory issue, and you try the case and you find fault, there may be some law out there that would suggest that you need to attach a document like that. But when you have a stipulated grounds, there is no, I'm not aware of any law that requires that the MDA be attached, which is exactly what you just said. But that's
So
my
let's
point.
say that you win on appeal. There's nothing to prevent the wife from filing a new petition for contempt and then just attaching the MDA to that petition, and then we're
The answer to that
cleared
question, again, you're asking me to give one of those advisory opinions that judges hate.
It's a hypothetical.
But the answer to your question is likely, again, is what I would
Okay.
tell you. And probably, and so I would tell you that. So, and again, the non-pro-tunc is the problem, all right, with regard to that particular scenario you gave as a hypothetical. So you got a non-pro-tunc where you're going back 10 years with respect to this particular order, and now saying it was omitted, and so now we're going to include it, and we're going to make it effective as of the date of the decree back in 2014.
Well, it would be effective the day it was signed.
It would be effective the day that it was signed, but they're saying now you want, if it's part of a decree, it should be part of the decree as of any time subsequent to this by making a motion to amend the decree and include it, or you could file.
About the fact that the decree specifically says it's incorporated word for word into this decree.
And again, if you had filed it, you served it, you would have that, but it would go forward from that day. I mean, to be blunt, you're looking at what they're trying to do is to get the attorney's fees from the period of, there's no big secret here, from the period of time of 2014, to the extent there is any, all the way through the date of the next trial is what you're suggesting. Whereas I would submit to you that if a petition's filed, it would be from the date of that petition, if in fact it's effective. And more importantly, the nunc-pro-tunc is not to be used for just something that's, quote, admitted. It is to be used if the court intended it. Unfortunately, or fortunately, it doesn't matter how you want to word it, this judge doesn't know. She found no notes. She made a point of that. In fact, she stated when she ordered it, she had 10 years with nothing, is what she said specifically. So that's the reason why, and I've run out of time, I'm over time, and I apologize.
Let me ask you a question
Sure.
to make sure I understand. Is your position that the MDA was not incorporated into the final decree because it wasn't attached?
I'm saying it's not clarity to the order that was granted for the divorce.
What was, I'm sorry, go ahead.
So that it provided the terms and conditions of the MDA within the order.
Okay.
I hope that
You
answers
have your
it.
time for rebuttal.
May it please the court, my name is Jeremy Cawthorn. I'm with the law firm of Patrick Beard, Shulman, and Jakeway, and I represent Jill Moon, who is formerly known as Jill Howe. We are here before this court because of what I will deem procedural gamesmanship by Mr. Howe, as he seeks to avoid the application of a contempt remedy for his willful failure to pay $2.5 million to Ms. Moon on or before December 20, 2022, as required by the parties' marital dissolution agreement. What is at stake is whether the Hamilton County Chancery Court can enforce its order or not. What is also at stake is whether contempt remedies are available to Ms. Moon as she seeks to enforce the court's order. As Mr. Konvalinka has alluded to, attorney's fees is a remedy for contempt that may not be available under the precise terms of the contract. It was certainly not necessary because it was contemplated as identified in the express language for the MDA to become part of the final decree of divorce, become an order of the court, and be enforceable by the Chancery Court. What I think is there's confusion with the incompatibility of Mr. Howe's positions. On the one hand, I think it's a confounding contradiction of positions that the final decree, which expressly incorporated the marital dissolution agreement, made it an order of the court, is somehow insufficiently clear to hold Mr. Howe in contempt, but simultaneously it is, in context of the entire record itself, sufficiently clear not to allow the trial court, which is the master of its orders, to exercise its discretion under Rule 60.01. Respectfully, it can't be both ways. What both the MDA and the final decree reflect the parties and the court's intention for the MDA to be incorporated into the final decree of divorce. Don't take my word for it. Look at Mr. Howe's verified answer with respect to this marital dissolution agreement. In Technical Record Volume 2 on page 225, Mr. Howe signed the verified answer under oath. On page 222 in paragraph 2, Mr. Howe cites the MDA. He quotes precisely from the MDA, and then he states the MDA speaks for itself. In paragraph 3, he admits that he did not pay the $2.5 million payment due under the MDA, and he admits that he prepaid obligations under the MDA through October 2022. In paragraph 4, he states the MDA speaks for itself. In the second part of paragraph 4, you'll see that Mr. Howe then claims that he cannot be held in contempt because, quote, the final decree references a marital dissolution agreement. It does not sufficiently identify such document, nor is there any marital dissolution agreement attached to the final decree. And his argument is that because of that, there is a lack of clarity and a lack of unambiguity with respect to being able to enforce the final decree. This is after he has quoted from the marital dissolution agreement, after he claims that he's abided by it. And when you take those terms and you look at the marital dissolution agreement that Chancellor Fleener ultimately physically added to the file, they match up exactly. You'll note that in the answer, Rule 10.03 is not referenced at all, period. There is no request for a dismissal because of a lack of the marital dissolution agreement being attached to the petition or within the record. It's a defense. What I think if the court will look at what preceded that answer, it further shows that there's no concern or debate about what the marital dissolution agreement said. Mr. Howe, on December 17, 2013, initialed every page, and his signature was notarized. And that's on December 17, 2013. 6 days later, Mr. Howe, through Mr. Konvalinka, moved the court to approve the marital dissolution agreement signed on December 17, 2013. In February or March 2014, the record isn't precisely clear, the parties participated in a final hearing and presented the MDA that they signed December 17, 2013 to the trial court. March 3, 2014, the trial court entered a final decree following the hearing and confirmed that it reviewed the MDA and that the parties presented, found it just, fair, and equitable, and incorporated all of its provisions by reference. That final decree is signed by Mr. Konvalinka on behalf of Mr. Howe, Ms. Raymer on behalf of Ms. Howe herself, and Mr. Howe himself. You'll note in the final decree there is no indication of any exhibits, and yet the permanent parenting plan is still attached. Ms. Raymer, as has been made a big deal, believed when she was seeking contempt that the marital dissolution agreement was in the record. There's no indication in the final decree that it was intended for the marital dissolution agreement to be excluded from the record. And so what we know is that Chancellor Brown had it in his hands just as he had the permanent parenting plan. We know that counsel expected it to be in the record somewhere, and it wasn't. And when Chancellor Fleener reviewed this issue, she exercised her discretion under Rule 60.01 to add the marital dissolution agreement to the record to avoid this dispute about clarity. May 12, 2014, Mr. Howe agreed to a modification to paragraph 4.6 of the final decree about Ms. Howe's car because there was a title issue. 4.6 matches up with the marital dissolution agreement that discusses the car that was awarded. From 2014 to 2022, Mr. Howe prepaid his obligations according to his answer for a total of $11,175,000. February 17, 2023, $2.5 million was not paid, and that led to the petition for contempt. June 16, 2023, Mr. Howe filed his verified answer, and after the answer was filed, Ms. Moon listed the marital dissolution agreement as an exhibit. There was no objection to the marital dissolution agreement's authenticity as required by the local rules. Mr. Howe identified that Ms. Moon's exhibits would be his exhibits at trial. And then following the dismissal on June 3rd, 2024, Mr. Howe at no point in time objects to the marital dissolution agreement signed on December 17, 2013 as being an authentic document. It is our contention that the dismissal without prejudice is an error. It should have never occurred. What happened is that it was incorporated by reference, and there is a recent case out of the Middle District of Tennessee, It's called Duffy versus Duffy, 2024 Tennessee Appeals, Lexus 503, Tennessee Court of Appeals, November 25, 2024. I verify that there's no further appellate history. I don't believe an application of the Supreme Court was filed. And the Duffy Court of Appeals took an incorporated permanent parenting plan that was not a part of the record, had been referenced as an exhibit during the hearing, incorporated that into the final decree, and held that the permanent parenting plan did not have to be in the record for that to be a final order, and found that the time for appeal had passed. And specifically, Duffy looked to Black's Law Dictionary with the definition of incorporate and determined that that secondary document, the permanent parenting plan, was incorporated into the primary document and should be treated as contained within the primary one. Duffy Court refused to accept, quote, a blanket requirement that for an order to effectively incorporate a document, said document must be directly attached to the order, end quote. The Duffy Court of Appeals acknowledges and notes the better practice, of course, is to attach it to avoid any dispute. But when there's no dispute as to the accuracy of the document, it does not have to be it does not have to be physically incorporated for it to be part of that original record. There was this argument, the Convalinkas Tennessee Supreme Court case, which I think provides a lot of guidance on these elements. And what Convalinka indicates is that the court must view the order through an objective standard. First, of course, it looks at the plain language of the order to determine what it says, but it also looks at, quote, the circumstances surrounding the issuance of the order, including the audience to whom the order is addressed. And then the Lamar Advertising Court case, 313 Southwest 3rd 779 Tennessee Court of Appeals, discusses that courts should interpret an order to, quote, give effect to every part of it, end quote, and that you're supposed to read the entire record to determine what the order means in context. We've cited the Dukes case, where there was an argument about contempt, where it showed that consistent actions with the order, which undercut the concept that it was ambiguous, which is what we have here with Mr. Howe paying for a series of years. We looked at tomes. We've cited the Metro government case. And what our contention is, in context, this was very clear. There's been no dispute. He cited the MDA. There's no dispute over which MDA was at issue, and therefore it was enforceable because it was incorporated. There should have never been a dismissal on a Rule 10.03 basis.
Would you agree that looking at just the order itself, the trial court had just the order itself without the MDA, that there's no way for the trial court to know what those specific provisions are in the MDA?
Yes, Your Honor. I agree that looking at the plain language of the final decree, that there's no way to determine what the marital dissolution agreement said. But it was incorporated by reference. And I think one of the issues here is, and that's why I think the Duffy case that I cited is so important, is because an incorporation by reference into a court order is sufficient for the order to withstand. I think you also have to look at, we have Mr. Howe admitting under oath he knows precisely what the marital dissolution agreement is that's referenced in that final decree. I don't believe there's an ability to sidestep that. And to the extent, and then that leads to the 60.01 issue, Your Honor. And if, in the event that there's a lack of clarity because the marital dissolution agreement was not physically within the file, Chancellor Fleener under 60.01 had the discretion to incorporate the marital dissolution agreement into the record, which he did. And there's argument about whether it was intended or not. Mr. Convalinka argues that because there's a change in the judge, that matters. It doesn't. He doesn't cite any cases that it suggests that. We've cited a reported case that says even if the trial court judge has no independent recollection, that the court still has the 60.01 authority. And what we do know is, and there's an argument that suggests that there's no indication in the record that the marital dissolution agreement was supposed to be incorporated. I would contend that's false. It's inaccurate. What the final decree says is it incorporates the marital dissolution agreement, it incorporates the permanent parenting plan. There's no exhibits listed in the final decree. The permanent parenting plan is attached. For some reason, the marital dissolution agreement was not attached, and Ms. Raymer believed that it wasn't attached. When it gets to the nunc-pro-tunc issue, because the final decree makes reference specifically to incorporating the marital dissolution agreement, that is the sufficient record in and of itself in the notation in order to enter a nunc-pro-tunc order. Because it's on the plain language of the final decree, we contend that it can be incorporated. We raised a Rule 15.01 issue because our contention is it wasn't until the last minute that the request for dismissal was raised by Mr. Convolink on behalf of Mr. Howe. It's not reflected in the answer, given that last minute ambush with this request for a dismissal when Ms. Raymer was anticipating being able to provide proof with the marital dissolution agreement. We contend that Rule 15 should have granted the amendment. The marital dissolution agreement could have been added to the petition, and as Mr. Convolink has acknowledged here today, that probably would have solved his argument at minimum. Where we are.
Counsel, let me, maybe I've missed it. Trial court applied Rule 60.01, correct?
Correct.
Was this a clerical error under Rule 60.01? I mean, isn't that kind of the first question?
Yes, Your Honor, and that's why I think that there is a lot of attempt by Mr. Howe to create this concept that Ms. Howe had some obligation to add the marital dissolution agreement, cast blame on Ms. Raymer as her counsel. There's no evidence in the record that this has anything to do with Ms. Raymer.
Oh, but my question, I'm sorry, because your time's up, but is it a clerical error? I mean, the order didn't say it would be attached. It just said it was incorporated. So was it a clerical error to not attach it?
Yes, Your Honor, it was a clerical error, and that's why the permanent parenting plan is attached to the final decree without an exhibit reference. And then the clerical error also applies to unintentional omissions. We cited the Woody case where there's an unintentional omission. It also applies when a trial court, it's in the trial court's discretion, if it elects and finds that it made a mistake, that the court order does not reflect its order. And here, the intention was the marital dissolution agreement was supposed to be part of the final decree. It was supposed to be enforceable. It was supposed to be part of the court order.
But it never said that it was to be attached. It just said it was incorporated.
That's correct,
So
Your
who
Honor.
made the clerical? I mean, I'm not looking to point fingers as to who's responsible for it, but was it the court clerk? Was it the parties? Was it the trial judge? I mean, who made the clerical mistake?
Your Honor, our contention is that it was the marital dissolution agreement was provided to Chancellor Brown, and we have no explanation for why it did not end up in the court record after Chancellor Brown had it. That is reflected in the final decree, and I think an element that's pivotal for this is reviewed under an abuse of discretion standard. Chancellor Fleener reviewed the facts and circumstances, reviewed the file, determined it was in fact a clerical error, was confronted with this allegation that this was somehow Ms. Moon's fault or Ms. Moon's counsel's fault, rejected that contention, adopted the marital dissolution agreement to give voice to the final decree.
Clerical error was not attaching it.
That's correct.
Okay.
And I think it was an inadvertent omission as found by Chancellor Fleener, and to Mr. Convolink indicated that he thought there was an issue with a lack of independent recall about this. That is incorrect under the reported case that we've cited in our papers.
Okay, thank you.
Thank you, Your Honor.
Wait, counsel, just a
I may
second.
be missing something here, but how could it be a clerical error for not attaching it, and it only makes reference to it, incorporated by reference? It does not say or make a requirement that it be attached.
And I think that,
The final decree stands by itself, doesn't it?
well, Your Honor, I think that the final decree has to be reviewed in context for the entire court record. I believe that the 60.01 relief was likely unnecessary because of the error in dismissing the case because of the incorporation by record. But either that final decree was deprived of its voice, deprived of its force of law by the failure to attach the MDA that was in Chancellor Brown's possession, as indicated in the final decree, or it was not. And so the clerical error, as found by Chancellor Fleener, was the lack of attachment when Chancellor Brown had the document in hand.
Okay,
Anything else? Thank you, Your Honor.
We'll hear from the appellant rebuttal.
The statement that Frank Brown had possession of the marital dissolution agreement is not in the record. There is in the record that he reviewed the marital dissolution agreement.
And he signed initialed every page,
Well,
or,
you're talking about my client, not Frank Brown, did not issue.
Okay, I'm sorry, yes.
I'm talking about the chancellor.
You're talking about the chancellor, yes, I'm
Because
sorry.
you've just been told he had it, but we don't know where it is. I beg to differ in the sense that he didn't necessarily have it. He did review it. I've been to many a judge with an MDA. I'm not saying this happens, but they look at the MDA and then they hand it back to the attorneys with regard to it and in connection with this. But what's more important, so to suggest that Frank Brown had it, it was in the auspices of the court, I don't think that is a correct statement. We don't have any evidence of that. What you do have evidence is that he did review it. Now, with respect to, there's been no addressing what happened when we filed that petition for contempt. And I answered that petition for contempt. I quote ambushed Ms. Raymer by giving her more than 200 days before the date of the hearing to attach the petition, to attach the MDA if she wanted to attach it. They're now saying that when we contemporaneously did exhibit list, at least it's a little bit softer than it was in their brief, where I agreed that the MDA was going to be entered. I did not. What I did was, like I do most things, I say I may use the following exhibits. And one of the ones you always put on the end, plaintiff's exhibits if you're the defendant, and if you're the plaintiff, you say defendant's exhibits. But that's not suggesting that I, quote, agreed with that, and with respect to this. So, the point about the non-pro-tunc issue, again, I would tell the court, that's going back 10 years with respect to this. There was no requirement that it be attached. They're trying to suggest to you there is a requirement for it to be attached. There's no law that says it has to be attached. And so, again, if you want to attach it, I think you do it as of the date of the grant of letting them attach it with respect to the 6001. But again, that's not a court clerical error. That is an addition or supplement to the record that should have been done at the time that they wanted to, we've had discussion about Rule 60 even in the year 2014, if you will notice. And we're having discussion again in the year 2023. If you want to make it part of the record, the first time they made it part of the record is when Ms. Howe gave an affidavit in support of either the motion to alter or amend or the Rule 60 motion itself. But as you have asked, this is not a clerical error of the court. And that's what Rule 60.01 is. You go to Rule 60.02 if it is something else. If it's an error by counsel or error by clerk, or I mean, not the clerk, but error by me or the other counsel, you use 60.02. And that's the reason, bluntly, you probably didn't see it when it was filed in 2023, because they didn't want to admit for the first time that they didn't put the MDA there. Again, I can't tell you, but that's speculation on my part. And do you have any questions? Because I think I've beat this horse to death.
I hear none. Thank you.
Thank you.
All right, thanks to counsel for both sides. We appreciate your arguments this morning and your briefs on this matter.